Welcome to Ask a Patent Lawyer with noted inventor and patent attorney Chris Maiorana. Each week, Chris answers your questions on patents, trademarks, and inventions. Now, here's Chris Maiorana.
What is a continuation application?
So a continuation application is normally a second, third, or fourth application that is filed that uses the same specification and drawings as a parent application. So if you use the same specification and drawings, your continuation application gets the same filing date as your parent, and then you write new claims for the continuation. So it's a second application based on the same subject matter as the parent application.
Are there types of continuation applications?
There are. So what we tend to call a true continuation is when we use all the text from the parent application and all the figures with no changes at all. There's a situation where you can add some figures or description in your specification. That's called the continuation in part. So that, say you had 10 figures and drawings, or 10 figures with specification description of those figures, and you wanted to add two more. So the two more figures would not get the earlier filing date because those are new matter, but the 10 figures would get the earlier filing date. So that's called a continuation in part, and both applications under the new law are filed under Rule 53B.
So why not just file a new application instead of a continuation?
Right. The main reason is that you get that earlier filing date, which can be important if there's prior art that you don't want used against your new application, or if you offered your invention for sale after the first application was filed, but more than a year before the continuation application was filed. So if you get that earlier filing date, it's really helpful on your on-sale bar issues and your filing date issues for prior art.
So why would a client need more claims on the same specification?
There's a number of strategies that are at play. One core issue is that the continuation application normally lets you get broader claims than the parent application. And that's just part of the bartering system with the patent office. So the patent examiner has limited time to examine these things. They tend to be a little bit picky about what they're going to allow in a case, and they always have a concern whether they're going to allow something that their supervisor thinks shouldn't be allowable. They get a negative credit on their review for that. So if you have a continuation application that is a familiar case with the patent examiner, he basically picks up his strategy where he left off and says, oh, okay, so I allowed the case with these limitations. I see that now they're taking out these other limitations. He says, oh, yeah, I can allow that one too. So it's almost like a poker game with these examiners where you're just moving the line that's more valuable to your client. So that's the one reason, just for purely getting a broader claim on the same subject matter. There's other situations where a competitor comes up with a product that you know in your heart is infringed by your claims, but they use a little bit different wording on some things than you do. So you could target their commercial embodiment. This is depending on the filing date. And you can target their embodiment and make claims that for sure cover that. Maybe use their exact words that they're using. And the other one is if you have a licensing portfolio where you just want a lot of patents that are very dense in a certain subject matter, where you want a spectrum of claims in that subject matter to really enforce against a particular competitor.
Okay. So is there a limit on how many continuations that can be filed?
There's not a limit. We usually say as a good rule of practice, you probably want to file at least 1 or 2 continuations. That's with that idea of pushing the examiner for broader material. If you're going to get into a licensing portfolio, you can do quite a few follow-up applications to really knock down certain areas. And when you go to sell a small company, there's the IP portion of your company has a certain amount of value, and you do get into this bean counter mentality where they're going to look at your quality patents for sure, but they're also going to say if one company has 2 or 3, they just don't think that's as good as if you have 20, 25, or 30 issued patents. So the continuations are a way to get your portfolio numbers up that compare well with other portfolios.
Have your clients benefited financially from doing this, from filing continuations?
I think so. We've had a few clients get rather attractive sales deals on their companies in general. And for sure, there was a large due diligence portion on the patent portfolio. So that, I would say, helped them a lot to get a much bigger number on their sale of the company. And there's also, we had a company that went to litigation to enforce a patent. They had 2 continuations, and most of the unexpected turns in the litigation were covered by claims that were in the follow-up continuation. So on that one, client saved millions of dollars.
Thanks for listening to Ask a Patent Lawyer with noted inventor and patent attorney Chris Maiorana. Join us next time as Chris answers your questions on patents, trademarks, and invention.